A well-regulated militia being necessary to the security of a free state. The right of the people to keep and bear arms shall not be infringed. Welcome to another edition of Bearing Arms, Cam & Company. My name is Cam Edwards. It is great to have you with us. On the program today, we're going to talk with Scott Bach, Executive Director of the Association of New Jersey Rifle and Pistol Clubs, about perhaps the likeliest case that the Supreme Court may take up next, dealing with our right to keep and bear arms. Now, the court is going to consider in conference on Friday 10 Second Amendment-related cases. They could take more than one, and they could also pass by all 10. It might be a few weeks before we find out what the court is doing, but we do know it takes 4 justices to agree to hear a case. We know that we have 4 justices on the bench that have said it's time for us to hear one of these cases after the decision came out earlier this week, mooting the New York City gun challenge. You had Justice Samuel Alito write a dissent, joined by Justice Neil Gorsuch and Clarence Thomas, Justice Brett Kavanaugh writing a separate opinion, and all 4 of them stating, listen, we've got to hear one of these Second Amendment cases because these lower courts are just ignoring what we've said in Heller and McDonald and the Catano guidance. These are the only Second Amendment decisions that the court has taken up since 2008. And these 4 justices say that it is time for this pause on Second Amendment cases to end. So you do have the 4 justices needed to hear one of these cases. The question is, what case might it be? I think the biggest question is what case might it be or cases? And again, Scott Bach with the Association of New Jersey Rifle and Pistol Clubs is going to join us here in just a moment or two, talking about, I think, perhaps the most likely contender to be the next case heard at the U.S. Supreme Court. But we do have some headlines to get to before we talk with Scott Bach, including news out of Canada, where the Globe and Mail newspaper is reporting that a sweeping gun ban by the Trudeau administration is imminent, could come as early as Friday. And the Globe and Mail says this is going to be done, apparently, without a vote in Parliament. They say this is, in essence, a done deal, that the cabinet has already agreed to the changes, but they have not publicly announced them yet. And the Globe and Mail newspaper says this can be done without any sort of vote by Parliament. An order in council, basically a cabinet-level decision by the Trudeau government, could impose a ban on, quote-unquote, military-style firearms across the entire nation. This would be coupled with a compensated confiscation program, although that might come after the ban. The ban could be announced, the ban could go into effect, and then at some point in the future, you could have a compensated confiscation program. Prime Minister Trudeau also may announce that it is okay now for cities to ban handguns across the entire nation of Canada. And again, that could be coming as early as Friday. These measures have been in the works for quite some time, but you had this active killer in Nova Scotia just a few days ago, killed 22 people, dressed up as a Royal Canadian Mounted Police officer, by the way, using a car that was tricked out to look like an RCMP vehicle, and apparently using firearms that were illegally obtained. But Justin Trudeau using this as the backdrop again to push through that sweeping gun ban. This, according to the Globe and Mail, and we'll have much more information for you on that story in the days ahead. Also, we've got an update for you out of Jackson, Mississippi, where Mayor Chokwe Lumumba has instituted an open carry ban. That is supposed to expire today, that order. But it's also being challenged in federal court because on the face, Mayor Lumumba's decision to unilaterally declare that open carry is illegal for the time being in Jackson, Mississippi, flies in the face of the state constitution, flies in the face of the U.S. Constitution, ignores the language of the Mississippi emergency management statutes. You've had everybody from the Attorney General of Mississippi, Lynn Fitch, to the Jackson City Council, which unanimously opposed the mayor's move this week. He doesn't have many allies, and now adding to the growing voices criticizing the mayor, you can chalk up the U.S. Attorney for the Southern District of Mississippi, guy by the name of Mike Hurst, who is out with an op-ed in the Clarion Ledger newspaper in Mississippi, absolutely blasting Mayor Lumumba's decision. I should note, by the way, that I have invited Mayor Lumumba on this program Reached out to his office via email, heard nothing back. Reply or sent another email yesterday, heard nothing back. Reached out to the mayor on Twitter, heard nothing back. So Mayor Lumumba is apparently very happy and willing to try to deprive people of their constitutional rights, but he is not willing to face, he's not willing to face a tough but fair interview with a Second Amendment supporter, which is a darn shame. I got to say, if you watch this program on a regular basis, you know that I treat everybody with respect, try not to engage in name-calling, don't believe in stupid straw man arguments. If I'm able to sit down with somebody who I disagree with, we're going to have a substantive conversation. Trouble is, not many of the folks I disagree with want to have a substantive conversation about gun control. In his op-ed in the Clarion Ledger, Hurst says that it is false for the mayor to say that many of the killings in Jackson could have been avoided if people would not have had a right to openly carry firearms. He says our office, the U.S. Attorney's Office, works closely with the Jackson Police Department, and I haven't seen a single case where a killing in Jackson could have been prevented if open carry rights had been revoked. The mayor's illegal order will only disarm law-abiding citizens and result in more victims. And he says, despite the statement to the contrary, the mayor also knows full well, as a former criminal defense attorney, that the right to openly carry firearms is not interfering with law enforcement taking criminals off the street. For more than 50 years, he says, the U.S. Supreme Court has authorized law enforcement to stop a person and investigate whether a crime has been committed based on a reasonable suspicion, a much lower standard than the probable cause standard mentioned by the mayor. Nothing, Hurst writes, prevents a police officer from asking questions of anyone, even with no basis for suspecting that a crime has been committed. Will the mayor extend this order as he threatened to do earlier this week? I guess, we'll know here in a few hours. I originally suspected that, yes, he would. Because I do believe that this is a publicity stunt more than it is a real public safety initiative. Given the lack of support that the mayor has received from city council members, to me now it's 50-50. I think it's all up to Mayor Lumumba's ego as to what he decides to do. Is he going to try to keep this edict in effect and then face the federal lawsuit, knowing that he's likely to lose, but he's likely to generate headlines in the meantime? Maybe. I guess we'll have an update for you on tomorrow's Cam and Company out of Jackson, Mississippi as well. But I do suspect that if the mayor doesn't voluntarily rescind this order, it's going to be stopped in pretty short order by a federal judge. All right, now on to our conversation with our friend Scott Bach, Executive Director of the Association of New Jersey Rifle and Pistol Clubs, who I spoke with yesterday about a case called Rogers versus Gruwall. This is a case dealing with New Jersey's carry laws. And I think it is quite likely that this will be the next case that the Supreme Court takes up for reasons that Scott Bach and I get into. Take a look and a listen. Scott, thank you, sir, for coming to the program. It's good talking to you today.
Great to be back, Cam.
I think all of us as gun owners are a little disappointed by the Supreme Court's punting of the New York State Rifle and Pistol Association case earlier this week, but there is some good news. It's not a guarantee, but the Supreme Court listed just the same afternoon, actually, that it mooted the New York City case. It listed 10 other Second Amendment cases that it will consider in conference on Friday. We could learn as early as Monday if the Supreme Court's going to take one of these cases. And a lot of folks, Scott, who watch the court closely, have said that they think a likely pick for the Supreme Court to take, if they do take one of these Second Amendment cases, is a case out of New Jersey dealing with the right to carry laws. It's a case called Rogers versus Gruwall, and it is a case that was brought in part by the Association of New Jersey Rifle and Pistol Clubs, was it not?
Yes, indeed it was. We are one of the plaintiffs in the case and the driving force behind it. And it's a very exciting time because New Jersey probably has the worst right to carry standard, the most vulnerable to attack in the country. Okay. Although we technically have right to carry, the standard is you have to meet a standard called justifiable need in New Jersey, which is so onerous. I like to say by the time you'd qualify, you're already dead. Okay. Technically, you have to prove the urgent necessity for self-protection with specific threats or previous attacks, actual threats or attacks, which demonstrate a special danger to life that can't be avoided by any other means than issuing a permit to carry. So it's impossible. And the other thing, there's a lot of people talking about the Rogers case. Right to carry in New Jersey has a special, it's not this discrete thing that can just be popped out of the law the way New York City tried to moot the issue that came up in the city case. The right to carry in New Jersey, having a permit is actually something that cleanses all possession of firearms. In New Jersey, things are backwards, right? Everything's banned except where it's allowed, unless you have a carry permit, in which case it's all allowed. So they can't just snip something out of the law to try to moot it. It's a much harder thing to do. Plus, New Jersey lawmakers tend to be very arrogant and probably think they will prevail and are not inclined to do anything like what New York City did.
It is interesting. I agree with you, and you obviously know New Jersey politics far better than I do. But you look back, and Illinois has concealed carry because state lawmakers basically were convinced, okay, we're not going to appeal this challenge to the Supreme Court. Seventh Circuit Court of Appeals had ruled that Illinois' complete ban on the carrying of firearms violated the Constitution, and they bit the bullet, no pun intended, rather than take that case to the Supreme Court. Same thing happened in Washington, D.C. with their good cause requirement. Gun control advocates convinced local leaders there, don't appeal this to the Supreme Court, take the loss. That way you don't set precedent across the country. But, you're right. I mean, you look at the New Jersey case that's before the court. There's another case out of Maryland challenging that state's concealed carry law. And again, in Maryland, Governor Larry Hogan, he might sign a shall issue concealed carry bill. I wouldn't be surprised if he did, but I don't think lawmakers in Annapolis are going to give gun owners that relief. And I think that's absolutely right in New Jersey, between the acrimony that the legislature has shown to gun owners, and then the hostility towards the Second Amendment that's been evinced by Governor Phil Murphy. I agree with you. I think that this is likely to remain a live issue. And let's talk about that standard that you just brought up here a second ago. It seems to me that if we have a right to do something, and I'm going to borrow a phrase from, I believe, Judge Dermot O'Scanlan in the Ninth Circuit Court of Appeals, if you have a right to do something, then the average American has to be able to do it, right? And so if you've got the right to keep and you've got the right to bear arms, but the average resident of New Jersey cannot bear arms, there's no way that they're going to be able to get a concealed carry license. Open carry is not allowed. Well, then that right isn't just being regulated. That right is absolutely being infringed.
There's no question about it. And the infringement is deep and it's long-standing and it's undeniable. Okay, we're in lag time in New Jersey. The Heller and McDonald decisions, New Jersey's reaction to that was, okay, very nice. We're going to go ahead and do what we want anyway. And, we're still in lag time because it's taken this long for a challenge to be ripe. Listen, whichever case makes it, and I'm presuming one of the cases is going to make it, clearly the U.S. Supreme Court has been ignored on Heller and McDonald. Okay? The lower courts are trying to redefine and rewrite it and claim that it means something other than what it means. And it seems to me that what's happening in the current U.S. Supreme Court is they're itching to say, no, it's going to be this way. And, whether it was the New York City case or whether it's the Jersey case or some other case, it seems to me they are eager to raise the bar on Heller and make it so that it can't be misinterpreted or rewritten. Okay? We think the Jersey case is probably one of the best hopes for that because it's just so egregious. It's so simple. It's not a secondary or tertiary issue that's far extended from the core Second Amendment right. It's the right to keep and bear arms. It directly affects the right to bear arms, and it's a denial. Technically, we have a statute that says you can, if you can meet these hoops, but in terms of practice, nobody can qualify.
Well, I was going to say, there are only a few hundred active concealed carry licenses in the entire state, right?
Yeah, and most of them are, maybe retired police.
Right.
Listen, in the predecessor to the Rogers case, which the Supreme Court didn't decide to hear, but in that case, out of New Jersey, we had plaintiffs. We had a civilian FBI employee, civilian, so he couldn't carry guns, who feared for his life because of his employment. And, the New Jersey courts said, sorry, no Second Amendment for you. We had somebody who was kidnapped, twice, thrown in a trunk in a case of mistaken identity, who couldn't qualify for a carry permit. This isn't like a technical thing. This is a systemic, institutional, state denial of fundamental constitutional right, and it must end, and the time is now, one way or the other. And I think the Supreme Court means business now. And in hindsight, we might find that the mooting of the New York City case actually accelerates things, because the New York City case would have been, if it ruled in our favor, an extremely narrow decision just about what the rules are. Mm-hmm. If they were to take Rogers, they have to decide both the rules and right to carry. So it's a two-step now. So, listen, I'm not predicting that anything could happen. Maybe they'll just deny to hear all the cases that they've suddenly, put on for Friday.
Look, anything is possible, but I look at the math. It takes 4 justices to agree to hear a case. It takes 5 to win a case. You had 3 justices dissent from this opinion in New York State Rifle and Pistol Association versus New York City. Justice Alito wrote the dissenting opinion, joined by Justice Gorsuch and Justice Thomas. And basically they argued, look, this case is a live case. We didn't need to moot it. We do need to take these Second Amendment cases. Justice Kavanaugh wrote an opinion concurring with the majority that New York City had mooted the issues, but also agreeing with Justice Alito and his colleagues that, the court really does need to hear a Second Amendment case, and sooner rather than later. That gives you the 4 justices on paper anyway, right? And then it just becomes a matter of, is there going to be a 5th justice, likely Chief Justice Roberts, but is there going to be a 5th justice if one of these cases is heard to actually rule in support of the right to keep and bear arms? But I'm with you. I hate to make predictions with the Supreme Court, because that is like the most leak-proof institution in Washington, D.C. But I feel fairly confident in predicting that one of these 10 cases will be heard by the court. Now, they may not announce this on Monday. They may kick these around in conference for a few weeks, but it's pretty clear to me that we've got the 4 justices on the bench right now that want to hear one of these cases. To me, the question would be, which one do they take? And it doesn't necessarily, they don't have to settle on just one. They could choose to take more than one of these cases.
They could, but I think that's highly unlikely. The Supreme Court moves very slowly most of the time, mm-hmm. and they pick and choose their issues carefully. I personally think that they want to clarify and enforce the Heller and McDonald rulings, and then apply it to the particular situation. The thing about a right to carry case is you get, like I said before, you get a twofer with that. You get clarification of the rules and a decision, hopefully a positive one, on the basic issue. But we have bigger problems if the U.S. Supreme Court finds that the right to bear arms is not part of the right to keep and bear arms. If that's their decision, we're in much deeper trouble. I also agree with you also with the pandemic stuff that's going on. Mm-hmm. Now is the moment when, eyes are wide open to the importance of the Second Amendment and the right to self-protection outside the home. So, in my opinion, it couldn't be riper right now. So, our fingers are crossed one way or the other, whichever case they take up, assuming they take one up. I think we're going to see some good things come out of the court. We hope it's the New Jersey Rogers carry case, because that one is, there's no counter to it. It's baked into the law. New Jersey would have a very tough time if it wanted to trying to moot it, because it's got its tentacles into like dozens and dozens and dozens of parts of the law that are unrelated to actual carry. So they can't just snip it, from the law. It's a much more involved process.
All right. Well, we've got our fingers crossed down here as well, Scott. I appreciate you coming on the program, sir. And hopefully next week we can be talking about a Supreme Court decision to hear the Rogers case.
I will look forward to it, Cam.
All right. Scott Bach, Executive Director of the Association of New Jersey Rifle and Pistol Clubs. Thanks so much for coming on the show today. Now, I'll admit, I'm actually hoping that the Supreme Court will agree to hear more than just one of these 10 cases that it's considering in conference. I would love to also see the Supreme Court accept the challenge to California's microstamping law that has been brought by the Second Amendment Foundation. We spoke with Alan Gottlieb about this earlier in the week, right after the Supreme Court mooted the New York City gun case, and he noted that the Second Amendment Foundation has 4 cases that are up in conference at the Supreme Court. One of them, again, dealing with California's microstamping law, which prohibits any new model of handgun from being made available for sale in the state of California unless it has the microstamping capability, which no handguns do, because California law requires that a unique code be imprinted by the handgun in 2 locations on every cartridge. And there's no way to do that. There's not. And so what has happened since this microstamping law has been put into effect is that there have been no new models of handguns made available in California. But not only that, existing models of handguns have fallen off of the roster of handguns that are allowed to be sold in the state when simple design changes are made. So let's say a screw gets moved from one location to another. California Department of Justice says, oh, that's a new model of handgun. Can you microstamp with it? No. Okay, well, it's got to go off the list. And so there are actually fewer models of handguns, each and every month in the state of California. This is a slow motion handgun ban is what this is. And it's been upheld by the Ninth Circuit Court of Appeals, but I would love for the Supreme Court to consider this case as well. Now, again, the justices meet in conference on Friday. The orders from that conference will come out on Monday morning. So we could learn as early as May 4th whether or not the Supreme Court is going to be hearing another challenge dealing with our right to keep and bear arms in the very near future. All right, let's get to today's armed citizen story, our good deed of the day, our recidivist report. We will start there. Actually, an update for you on a story we told you about last week out of Janesville, Wisconsin, where Marshawn Giles, 21 years old, he had pleaded guilty to 2 counts of first-degree recklessly endangering safety in a shooting back on March 30th, 2019, but he was unhappy after he pled guilty because he thought he was going to be getting 300 days time served credit, and instead a judge told him, look, no, that's actually going to apply to another crime that you've been in jail for. We can't give you a good time for both of these crimes, so that's going to be applied over there, and then you're going to get this 2-year sentence for your guilty plea. He objected, and unbelievably, according to the Gazette Extra, the prosecutor in this case backed off. Yeah. On Wednesday, Assistant District Attorney Mary Brico said she and defense attorney Michael Murphy had talked and that she agreed to amend her recommendation to just 1 year in prison and 2 years of extended supervision because Giles had pleaded guilty, believing that he would get the sentence credit. Brico said it was, quote, the just and fair thing to do. And she noted, this is the part that really steams me, and she noted that the change gives Giles even less time in prison than with the 300-day sentence credit. So in other words, not only did the prosecutor say, okay, we'll reduce the number of sentences, the prosecutor gave this guy an even sweeter deal than he was already getting after he had pleaded guilty to these charges. It's absolutely unbelievable to me. Now, the original facts of this case, we talked about he pled guilty to reckless endangerment. According to the Gazette Extra, a Chevy Sonic with multiple people in it was traveling behind Giles, who was driving an SUV in Janesville back on March 30th, 2019. Giles performed a U-turn, and then as he drove past the vehicle, he fired a handgun into that vehicle several times. Nobody was hit, but the car was hit several times. People could have easily been killed in that incident, and the prosecutor in this case, again, backing off of the already weak 2-year sentence and giving this guy just a year behind bars, giving him an even sweeter deal than he was originally going to receive. It is absolutely unbelievable to me that is happening, but that is exactly what's going on there in Janesville, Wisconsin. Now, our armed citizen story of the day from the state of Georgia, Richmond Hill, Georgia. No charges filed after a shooting at a motel in Richmond Hill injured one man. According to WTOC, this happened around 11:40 p.m. earlier this week, I think on Tuesday night. Shooter was originally arrested, but he was released after questioning because of self-defense. No charges were filed. Captain Jason Salicarios with the Richmond Hill Police Department says there was a verbal altercation, started to turn a little bit physical. One of the parties that was involved felt threatened, felt his life was in danger, so he pulled a gun and he fired a shot. He said, "This is a little unusual for us here in Richmond Hill. Parties involved not from Richmond Hill, they're from some other cities a little bit farther out. St. Mary's was one person from Savannah, one person from Pembroke, North Bryan County." Said these are not Richmond Hill residents. The investigation is ongoing. The authorities say that everybody involved is cooperating with detectives, but again, that shooting in a motel room there in Richmond Hill, Georgia, determined to be an act of self-defense. And finally, our good deed of the day from Suffolk, New Jersey, where a police officer, Keith Oler, used his patrol vehicle to push a burning SUV away from a Taco Bell and avoided a much bigger blaze. This was last Sunday. Late in the afternoon, officers responded to a vehicle fire at the Taco Bell, found an SUV in the drive-thru, flames licking out of the front end of the vehicle. Officer Keith Oler got behind the wheel of his SUV, pushed it into an open area of the parking lot. Stafford Fire Department arrived to extinguish the vehicle fire as well as a small blaze that had actually started at the base of the building near the drive-thru window. Police say the fire may have been started by a mechanical issue with the vehicle. Thankfully, the occupants of that vehicle were not injured. Building suffered only minor damage, again, because of the quick actions and quick thinking of Officer Keith Oler. As somebody who has had his car catch on fire, I know how quickly a car can be consumed. I know how quickly flames can spread. So truly in the right place at the right time and with the quick thinking, saving certainly some property, perhaps even saving lives. Officer Keith Oler there in Suffolk, New Jersey. We thank you, sir, for your very good deed. That is going to do it for this edition of Bearing Arms Cam & Company. I want to thank you for being a part of the program. If you missed, by the way, our VIP Gold Editors chat with Hot Air's Ed Morrissey and Jazz Shaw yesterday, you can watch it on demand if you are a VIP Gold member. We had a lot of fun. We're going to be doing more next week. So make sure that you sign up, become a VIP Gold member, help support the Second Amendment journalism we do each and every day at BearingArms.com. And you get exclusive access to things like those live chats, commentary, analysis, and more. You can also subscribe to Town Hall Media on YouTube or the Bearing Arms Cam & Company podcast on Apple Podcasts. And that way you never miss an episode of this program. We'll be back tomorrow with more of the latest Second Amendment headlines from all across the nation and perhaps even with our neighbor to the north as well. Until then, be safe, be well, and be free. We'll see you soon with more Bearing Arms Cam & Company.